Okay, welcome everyone to the second session in our Know Your Rights series, which we will be focusing on answering some kind of commonly asked questions about your rights as an employee in Ontario. My name's Hannah Neff, and I'm a career resource advisor with Careerspace at Trent. So for this session, we're happy to partner with the Peterborough Community Legal Centre, Consent at Trent, and the Trent Central Student Association. So we want to join this session just because as students or alum, you are having new professional experiences, and getting to know your rights is really an important part of that process. So today we're going to cover topics like your human rights at work, wages, accommodations in the workplace, and a lot more. And we really hope that this session will equip you with the knowledge and the resources to feel more confident navigating challenging situations, and just generally feel more well informed about your rights as an employee. So we'll do a couple of introductions to get things started off. So we are very fortunate to have with us today a few folks, and we'll start things off with Bree Polachicchio. So I'll pass it over to you, Bree.
Hi, my name is Bree Polachicchio. I'm the Vice President of Student Health and Wellness at the TCSA, and my role is to advocate and address concerns that any students may have.
Thanks, Bree. And over to you, Anne-Marie.
Hi, I'm a lawyer at the Peterborough Community Legal Centre, and right now I'm working on a couple of special projects relating to sexual violence and sexual harassment in the workplace. And so, but that today is going to be just about employment law in general and not focused on those topics.
Great, thanks, Anne-Marie. And we have a couple of folks here from the Consent at Trent team. So Kristen?
Hi, folks. So my name is Kristen Haynes. My pronouns are she and her, and I am the Sexual Violence Prevention and Response Manager at Trent. Though through Consent at Trent, Sarah will introduce herself next, but together we provide support, resources, and education around gender-based and sexual violence for the campus community.
Hi folks, my name is Sarah Simpson. I use she, her pronouns. I'm the Sexual Violence Prevention and Response Coordinator here at Trent University. So like Kristen mentioned, work closely with Kristen around building up capacity and building up and cultivating a consent culture within the campus, and definitely doing lots of fun coordination of events like the one we're doing today. So yeah, glad to be here with all of you.
So, as I mentioned, I work for the Peterborough Community Legal, it should say Center, sorry, I put clinic, but it's actually called the Peterborough Community Legal Center. And other than employment law, there's lots of other areas of law that you can get help with through the legal clinic for free. And one of these is being denied income support benefits like Ontario Works or Ontario Disability Support Program benefits or Canada Pension Plan. And one of the more popular topics probably for people on campus might be about housing. We help tenants who are experiencing problems with their housing, such as maintenance issues or being evicted for whatever reasons the landlord's giving. And my area of expertise is with the employment law. So that would be things around employment insurance, employment standards, workers' compensation. And then we also help with consumer protection, which would be things like around debt issues and your rights as a person who's having to deal with creditors, and human rights as well. That's also my area of expertise, including things like domestic violence. And as I mentioned earlier, right now I'm a project lead for a project called SHAPE. So that stands for Sexual Harassment Advice, Prevention and Education. So it's a campaign that we have going through several legal clinics where we're trying to increase people's knowledge and awareness of their rights around sexual harassment in the workplace and how they should be protected from that. And also increase employers' education about how to address sexual harassment when it happens in their workplaces and how to have proper policies. So before we get started, it's important to know that some of the topics I'll be covering today have to do with very difficult topics like discrimination and harassment. And so if that triggers things for you, please feel free to take a break. And you can message Kristen or Sarah for support if you need someone to speak to. And you can also chat with them. And then we have a virtual self-care room, and in the chat, you'll see the link to that. And you can go in there and just take a minute to recover. And then just remember to breathe. Breathing is very important. And you see with the strawberry, I love the strawberry because it has a pattern of breathing that regulates your breathing. If you follow it, it's pretty cool. So I love active participation. So if anyone has any questions, please feel free to put it in the chat, and I can address it either right away or at the end, whatever you're more comfortable with. And you can use the virtual hand to let us know that you want to speak up. If you want to speak up, then we'd love to hear from you about your experiences related to the topic today, if you have any. So this is a workshop about basic employment law rights. And I always like to start with the Employment Standards Act. So ESA stands for Employment Standards Act. And it governs very basic parts of all employers in Ontario, including things like minimum wage. So I didn't even realize that as of October 1st, 2023, the minimum wage rate actually went up to $16.55. So if you're working past October 1st, that's how much you should be getting paid now if you're a minimum wage worker. And there's a special student rate, which probably doesn't apply to most of you, for people that are 18 and under. And that is now up to $15.60 as of October 1st. Now, if you work more than 44 hours in any given week, they're supposed to pay you 1.5 times the regular rate of pay for every hour over and above those 44 hours. And also, every employee has a right to these public holidays. And if you work on a public holiday, for whatever reason your place of work is open on a public holiday and you work, then you actually get 2.5 times the regular pay. So instead of the overtime rate, you actually get 2.5. So it's a double and a half rate. And these are the basic dates that are legislated. So New Year's Family Day, which is in February, I'm pretty sure. Good Friday, Easter Sunday, Victoria Day, Canada Day, Labor Day, Thanksgiving Day, and Christmas Day. And it's not exactly 12, but it's almost one a month that is legislated. Now, there are definitely exceptions to these rules about public holidays. One of them is if your shop is small. So that's why, like, for example, you'll see convenience stores are often open on these public holidays because they only have 1 or 2 employees working there. But grocery stores will most often be closed because they can't operate with under 3 employees. And for whatever reason, there's an exception for nurseries, flower shops, and gardening centers. I guess that's so to give people the chance to do their gardening while they have a day off. And gas stations is pretty obvious why that would be. And also tourist areas, which can include certain shopping centers. Like, so for example, the Eaton Centre in Toronto is a tourist spot. So sometimes you'll see them open on a public holiday. So as an employee, they can require you, if they're a tourist area, to work on a public holiday, but you get the pay. And every employee is also entitled to 2 weeks of vacation pay per year. And if you work more than 5 years for an employer, that goes up to 3 weeks of vacation per year. And it should be at least 4% of your gross pay. The employers can always do more than these things, but they're not allowed to do less. So they have to pay you at least 4%. And they can pay it in a lump sum to you before your vacation is taken. That's the regular way There are exceptions, again, to almost all of this. There's some exceptions, but I won't get into them. This is the basics. And then finally, and this is a big area that we deal with at the legal clinic, notice of termination and termination pay. So unless you're being dismissed for cause, which is very rare that an employer has the right to dismiss you for cause, they're supposed to pay you termination pay. And that would be based on your length of employment with the employer, generally 1 week per year. So it starts out at minimum 1 week, and then it goes up by 1 week for every year that you've worked for the employer. One thing to know that's very important is that there's also something called common law notice. And it's much more than this termination pay for most people. So before you do anything around termination pay and you go to the Employment Standards Office and you make a claim, please seek legal advice about this common law notice, because you may actually be much better off going another route. Once you've made your claim with the Employment Standards Office, you can't then turn around and bring a civil claim against your employer as well. You have to choose between those two things. Who is not covered? So one area of persons who are not covered are people called independent contractors. And in our next slide, I'm going to get into the difference between an employee and an independent contractor. But if you're an independent contractor, basically a self-employed person working for yourself on a contract basis for different employers, you're not covered by any of these things that I just mentioned. So you're not covered for overtime, you're not covered for minimum wage or any of those other things. So here you'll see an employee would be, probably most of you would fit into the employee category, because generally speaking, you're working for one business and they're the ones telling you what you need to do, like they're guiding your job description, and they're telling you when to work, and they're deciding for you how much to pay you. So if all those things are in place, like you're working for one employer, you're doing something essential for that business, and they're providing you with all your work tools, your uniform, this and that, then you're an employee. And if you're in business for yourself and you're offering services, so say, for example, you were a computer specialist and customers are coming to you for computer help, but it's a whole bunch of different customers. So you're working for different businesses. Well, in that case, you would be an independent contractor, and you get all of the profit from that business. It's all yours. And you're the one who decides who to work for, when to work, where to work. And you decide also if you want to hire someone else to do the work for you. So that is basic differences between employees and independent contractors. And in some cases, there's another category which I didn't put in here, but there is an overlap here of something they've now deemed a dependent contractor. So a dependent contractor has some of each of the characteristics. They fall in between, but that's a category as well. So they get some of the things apply, and others don't for dependent contractors. Going back to because I missed a couple things on that previous slide. It's important to note too that if you work for a federally regulated employer, whoa, sorry, just got a bug attack. So for example, if you work for an airline or for a bank, or obviously for anything related to the federal government or post office or radio or TV station, you're governed by a whole different piece of legislation. So you're governed by the federal legislation. But if you actually really look at them and compare them, there's very few minor, very minuscule differences. So they're basically the same. It's just what body you go to complain if somebody breaches your rights. And that's again where you might, if you're not sure, you want to go get legal advice, because you don't want to start a proceeding in the wrong place and then have all that delay and maybe miss a limitation period. And it's also important to know that if you do want to make a complaint under the Employment Standards Act, there is a limitation period of 2 years. something to keep in the back of your mind. So go get legal advice sooner rather than later. Okay, so many of you are doing experiential learning, which is really great. Trent seems to be a fabulous university for this. And if the experiential learning was actually a placement program that was approved by your university and set up by them for you, then there's a chance that you may not be covered by the Employment Standards Act in that situation. And or if you're volunteering for a charitable organization, there's a chance you might also be exempt from those provisions that we just talked about under the Employment Standards Act. However, if you're working, you yourself take it upon yourself, oh, I want to be an experiential learner and I want to go, say, for example, do a summer job with this business. And they're saying to you, oh, even though we're a for-profit business, we don't really need students right now. So we'll take you on for free so you can get the experience. Well, that's not legal. So if the business is actually just using you as an employee to do the work for free, that's definitely not legal. So the only time they can do that is if essentially what they're doing for you is exactly like what you would be doing as an intern at Trent. So, and that there's more benefit received from the experience for you as the trainee than there is for the employer. And that you're not taking someone else's job. Like that's the really important part here. Like they don't want for-profit businesses using people to replace a job that would be paid. And they can't be saying to you, so they can't, an employer cannot force you to do training for free. So if the idea is you're going to do the training for free and then you'll have a job at the end, that's not legal. So if they're going to give you a job, then they have to pay for the training. Yeah, so that's basically the criteria there. I hope that's not too confusing, I just said. Perils of working under the table. So this is really important. A lot of the cases I have received at the legal clinic are to do with this exact thing. So people have gone to work for somebody. They're getting paid maybe quite decently, but there's no record of them being paid because they're getting paid in cash. The employer is not claiming them as an expense. They're not remitting anything for them. And so as a result, they're not covered by all of these benefits that you normally would be. So one of the big ones that I've run into is the Workplace Safety Insurance Board, because they cover people if you are injured at work. And they will provide things like treatment costs and loss of earnings and retraining. So you're really missing out if you're not covered by WSIB. And if you're working under the table, there's a chance you could still get WSIB if your employer was supposed to be registered, but you're taking a big chance that you won't be eligible for WSIB. So that's not good. The other problem is if you're working under the table because you're not really supposed to be working, or you're not supposed to be working for that particular employer due to your immigration status, if they find out, you could lose your visa completely and never be allowed back. So that's a huge risk. And as we just discussed, working under the table, chances are you won't be covered by the provisions of the Employment Standard Act. You're definitely not going to get employment insurance if you need that. And you're going to be missing out on your Canada Pension Plan contributions. So down the road, when you go to retire, your Canada Pension Plan is going to be much smaller than it would be normally. And you're not eligible for many, many tax incentives that the government bases on your income, because that income would not be registered in any way with the government. So I recommend that you not work under the table and not take jobs like that. It's very risky.
And for folks who are unfamiliar with that term, maybe working under the table, just, you know, working for cash or not filling out paperwork and providing, you know, receiving the hiring documents, tax forms, providing your social insurance number, all of those things upon hiring. Just to clarify too. Thanks.
Yeah, that's good clarification. So next I want to talk a little bit about human rights. And this is another area where I get lots of clients asking questions about because there's many, many different forms of discrimination that can occur in employment. And in the Human Rights Code, they list grounds, what they call grounds of discrimination. So some of them, these are the ones that are actually listed in the Human Rights Code. They're actually spelled out here. So race, ancestry, place of origin, color, ethnic origin, citizenship, creed, which is another word for religion, sex, sexual orientation, gender identity, gender expression, age, record of offenses, marital status, family status, and disability. Now, I'm not going to go through each and every one of those because there's a lot to say about every single one of these grounds of discrimination. But I'm going to cover some of the ones that you might more usually run into as a student. And just important to know that the human rights apply to every situation. So like we were talking about exemptions under the Employment Standards Act, there's no exemption here. It doesn't matter if you're being paid, you're not being paid, even illegal employment. Every kind of employment is covered by the Human Rights Code, as is volunteer work. And what is discrimination? So there's a lot of myths about what discrimination is. And I hear from clients a lot, oh, they discriminated against me. And what they mean is really, I was treated unfairly. And they're right. The treatment that they're describing is definitely not fair. However, to be discrimination under the code, it has to be based on one or more of the code grounds that I just listed to you. And there has to be an adverse effect on person being discriminated against. And you have to show that the protected characteristics, so the ground was one factor that related to the adverse treatment.
Anne-Marie, could I ask a question?
Sure.
I have gotten some questions from students about the record of offenses before.
Yeah.
And so could you clarify kind of what information an employer might have access to or they can ask for? And if you could clarify that.
So there is a lot of confusion around this too. And the case law is not very good in my opinion. But what it says is that record offenses, what it relates to is if you've been pardoned for a criminal offense. So you had a criminal record, you obtained a pardon, and now someone's still considering the fact that you had the criminal offense in relation to hiring you for your employment or keeping you on as an employee, even though you've been pardoned. If you haven't been pardoned, this does not apply. So if you have a criminal offense and the employer is saying, I can't hire you because of this criminal offense, that's perfectly legal, as long as you haven't been pardoned. If you've been pardoned, then they shouldn't be taking it into account. So you'll see in a lot of job applications, it says, do you have a criminal offense for which you have not been pardoned? That's what it should say. And so if you answer yes to that, then they can consider that as part of the reasons why to hire you or not to hire you. Does that answer the question okay? Makes sense? Yes, okay. All right, so a lot of times what employers do when they get served with the human rights application saying, I was discriminated against, they'll say, well, it's not discrimination because the person did not meet the criteria for the job, right? So what happens there is that the Human Rights Tribunal will only consider that as a defense for the employer if the employer could prove these things. So the employer has to show for it to be what they call a bona fide, that's Latin, occupational requirement. The employer has to show that the purpose of the criteria is directly related to the job and is an essential part of it. And they also have to show that they adopted that standard in good faith. So what I've seen in some cases is the employer will actually create a job description after the fact, right? So you'll have the person complaining to the Human Rights Tribunal, and all of a sudden there's a job description that never existed before that has all these things that the person doesn't need. And so that's bad faith. That would not be in good faith. In good faith would be a criteria that they adopted for a purpose rationally connected ahead of time and not after the fact. And they have to show as well, the employer has to show for it to be a bona fide occupational requirement, that it's necessary for that purpose. And so a good example of that whole test was in the Mayoran case, which was about a female firefighter who had many years, I want to say like 10 plus experience firefighting as a regular firefighter. And then she went to apply for forest firefighting. And in order to get that job, she had to pass a physical. And she tried several times to pass this physical and she could not. And then she found out that not a single woman had ever passed this physical. And so she challenged the physical on this basis. She said, well, I've been firefighting my whole life and I do a very good job. I'm certain I could do this job. So there's something wrong with this physical. The physical is, the standard is too high. And she won. So the court said, absolutely, it's not reasonably necessary for that job. You could do that job with the lesser standard of physical, like you're doing your job right now as a firefighter. So that's just an example of bona fide. That was not a bona fide occupational requirement. What might be, though, for example, would be for a pilot to be sober, right? So you want to make sure a pilot or a truck driver is not under the influence when they're driving or flying a plane. That would be a bona fide occupational requirement. So like I don't think we have to go through that, but examples of cases where the court has found it's not a bona fide occupational requirement are ones where, for example, they're just based on what the customer might prefer. So what would be an example of that? Like, so for example, requiring certain ways of dressing because you think that your customers prefer that people dress a certain way. So like doing gender-based dressing and saying, oh, you have to wear this type of clothing because our customers like it better. And relying on stereotypical assumptions linked to things to do with stereotypes about people who are covered by the Human Rights Code. And being very rigid about how a job is performed. So not being flexible or accommodating. So that would not be a bona fide occupational requirement. One of the very, very common types of discrimination in employment is to do with basically, I mean, you could cover all of this under racism, really. So it's race, ancestry, place of origin, color, ethnic origin, or citizenship. All of these things are listed specifically in the Human Rights Code. And examples of what employers might do on these grounds that's discriminatory is they might say, for example, we're not recognizing your foreign PhD because it's foreign, right? So we're not recognizing that you meet this criteria because your degree comes from a foreign university. Or they might differentiate between employees based on, language and communication difficulties. And they might not help them integrate into the workplace like they would every other employee. So an example of this would be hiring somebody for a job who just came from another country and you already hired them, you know that they're struggling with English and they're struggling with communication, and then you're putting them right on the phones to talk to customers without any kind of training, without any kind of support, and just basically setting them up for failure. And one of the cases, so the next one is not providing job-related learning opportunities. So there was a really interesting human rights case that I was reading that was about a bunch of computer engineers that came from South Asia. And they were finding that their coworkers were being sent to trainings and giving learning opportunities, and they were not. So one of the ways that they proved discrimination at the Human Rights Tribunal was just that. So, and the only difference between them and their coworkers was that they were South Asian and their coworkers were not. So they showed discrimination there. Being rejected because you're overqualified. So again, so it's a doctor coming from another country and being told that because they're applying for a job that's not for a doctor, they're overqualified, right? Even though they can't work as a doctor until they get qualified here. So that kind of thing happens all the time. And going along with that is this arbitrary requirement a lot of jobs have for Canadian experience. Why would you need Canadian experience specifically? What's the difference between Canadian experience and other experience? So often that's just a very easy way for employers to discriminate. And then there's obviously outright discrimination, which is very obvious, where people make jokes and awful comments that are based on race, ancestry, place of origin, color, ethnic origin, or citizenship. Once that the employee has shown that they've been treated in these kinds of ways, then it's up to the employer, like the onus shifts from the employee back to the employer. The employer has to show that whatever their criteria is, like Canadian experience, is a bona fide requirement. And as we saw, that's a difficult test to meet. They probably would not meet it in most circumstances. So the next area that's very common, and this is the projects that I'm working on are all about this, is people being discriminated based on sex, sexual orientation, gender identity, and gender expression. And actually all of this would probably fit under the heading sexual harassment as well. So what does that look like? Well, it can be things like people making jokes, insults, making humiliating comments. And those can be, comments could be verbal, or they could be text messages or emails, or even pictures. People engaging in behavior that is trying and is an attempt to reinforce traditional heterosexual gender norms. People refusing to refer to a person by their pronouns. People spreading rumors about other people with respect to their gender identity expression. People being outed or threatening to be outed. Intrusive comments, questions, or insults about a person's body, physical characteristics, clothing, mannerisms, or other forms of gender expression. So you can see how broad this is, very, very broad. And other threats, unwelcome touching, violence, and physical assault. Like, so there's a whole gamut of behavior that could fall under this. The other area that's super common, and actually I think most of the cases I got before I was working on this project about sexual harassment related to failure to accommodate employees in their employment. So, and the most cases involve some kind of disability that is either mental health related or neurodiverse related that the employer is refusing to accommodate. Every employer must accommodate every employee to the point of undue hardship. And again, that's an extremely stringent test, undue hardship. So it isn't just, oh, it's a bother to accommodate this person, or other employees will be jealous if we accommodate this person. It is more to the level of our business will go bankrupt if we try to accommodate this person, or the person really cannot do the job because their disability prevents them from doing one of the essential elements of the job, and there's no way to make up for that. And there's two parts to accommodation. One is procedural. So the procedural part is really about going through the steps to make a plan for accommodation. And substantive, and the substantive part is about actually really accommodating the person. So finding an individual plan for them. specifically that works to make it so that they can actually do their job despite their disability. And there's 3 principles that the Human Rights Tribunal applies to the accommodation to see if it was properly done. So the first one, the most important, has to be done respectfully and in a way that allows the person to maintain their dignity. And this is the part in my cases that I have found is the most lacking with employers. Very often they treat accommodation requests like such a big bother, and you know, the person who's requesting it gets ostracized because of their request for accommodation. And also accommodation has to be individualized. So it's that specific employee's needs, not people with that disability, but that specific employee's needs because of their disability. And it should allow them to be completely integrated and fully to participate in their workplace. And the goal of all accommodation is to create barrier-free work environments. And it's really important. So a lot of employers don't realize that, but we all benefit when people with disabilities are able to participate, and in so many different ways. And the people with disabilities as well benefit in so many different ways from being able to participate in employment. So as I mentioned, a lot of my cases involve people who have what they deem invisible. When I say they, like the Human Rights Tribunal actually has this whole category, a whole policy about invisible disabilities. And employers often poo-poo these kinds of disabilities and try to get away with not accommodating them. But there are some relatively easy ways to accommodate invisible disabilities. So some examples of appropriate accommodations would be allowing an employee to have a flexible schedule, allowing employees, or actually purchasing special software that makes a job easier for that person because of their disability, adjusting the application and an interview process to make it more accessible to people with different kinds of disabilities, restructuring jobs so that it emphasizes that person's abilities rather than their inabilities, and like task sharing. So that's quite easy to do in most workplaces. Another example of an accommodation would be to actually provide notice to people of meeting dates and topics, and modifying or allowing additional training and job coaching. So if somebody's struggling in a specific area because of their disability, offering them just that additional little bit of support can make a huge difference. And this is a big issue for a lot of the people that I've helped in the past, is allowing them to take time off when they need to because of their disability, and then not to punish them for that when they come back. So facilitating that can be huge. So that concludes the substantive part. Does anyone have any questions about all that? No?
Thanks,
Okay,
Anne-Marie. So that concludes the presentation portion.
yeah.
Okay, so I am just going to stop the recording so that if anyone has questions that they'd like to ask, they can do that without being recorded. So to those of you who are watching, thanks for joining. And just as an addition, if since we are ending the recording, I will include the notes as to how you can get in contact with Anne-Marie as well if you have follow-up questions. So, all right, thanks.